This page was created to teach Black history. Unfortunately, the American educational system was designed to exclude our real historical account, so we are here to dismantle it. It's time to enlighten those of us who have been kept in the dark. I am a Black man who didn't know enough about my own history, so I began to dig deeper and do my own research. Black history is American history, so I want people of all races and cultures to join together to learn our history as one. Here, I will share all of my findings. Please like, follow, share, and subscribe to Teaching Black History. The story of the Martinville Seven. On Saturday, January 8th, 1949, after Ruby Floyd, a 32-year-old white woman, entered a Black neighborhood in Martinsville, Virginia, to collect money for clothing she had sold. She had previously distributed Jehovah's Witnesses materials in the neighborhood. Residents warned her not to stay too long, noting the time as late afternoon. She passed 4 men at the railroad tracks and continued into the neighborhood, where she was later assaulted by some of those 4 and other men. At 7:30 p.m. after dark, she went to Mary Wade's house for shelter, showing signs of an assault. The Wades called an ambulance for her. Based on her account, in which she claimed to have been raped by 13 Black men, the police quickly arrested Frank Hairston Jr. and Booker Milner. 4 more suspects were arrested that night, based in part on the first 2 men's confessions. By the next morning, all men in custody had signed confessions. The last to be arrested, Joe Hampton, was taken into custody on January 10th. All but 1 man were in their early 20s. After being held by police overnight, the first 6 all signed confessions, implicating themselves and each other. All admitted to being present at the crime, including Joe Hampton, although not all took part in rape. Only one of the accused had a prior criminal record, and most of the men were employed. When the NAACP appealed their convictions, its defense team noted that when the police had questioned the men, they had been drinking for some time and they were not allowed to consult lawyers or their families. The officials separated the men. To protect them from mob violence, they took them to other jails outside of Henry County. The preliminary hearing occurred about a month later, and the grand juror 2 months after that. A grand juror, which included both Black and white members, indicted all the men. The judge appointed 7 attorneys for the 7 defendants indicated. Since they ranged widely in experience, he asked the more experienced ones to aid the newer attorneys. Efforts by the defense team to change the trial's venue from the Martinville Circuit Court on the grounds that sensationalist press about the events made a fair trial impossible were unsuccessful. Judge Keenan Whittle told the attorneys, "This case must and will be tried in such a way as not to disturb the kindly feeling now locally existing between the races. It must be tried as though both parties were members of the same race." The prosecution did not explicitly discuss race. It argued the case based on the preservation of the community's stability, not the protection of Southern womanly virtues, as had formerly been common. The trials were held back to back, each with a separate juror of 12 white men. The prosecution introduced evidence showing that non-consensual sex took place. Some of the defendants acknowledged having sexual intercourse with Floyd, but said that it was consensual, or that she did not resist or say no, either considered necessary as a condition to prove rape. Virginia law authorized capital punishment for accessories, parties to the acts of rape who did not take part in the act. On the stand, each of the defendants at least partially rejected his confession. In some cases, they said that the police had written the confessions, that the former account varied from a handwritten version, and that they had not fully read the police version when signing and did not recognize that their own accounts had been changed. No trial lasted more than a day, and the longest jury deliberation lasted less than 2 hours. The shortest was little more than half an hour. Although the defense attorneys pointed out circumstances, the juries quickly convicted each defendant and sentenced them to execution in the electric chair. Virginia had historically convicted and executed numerous black men accused of raping white women for most of its history. Only blacks were sentenced to death for rape. Since Virginia started using electric chair in 1908, all 45 of the men sentenced to death for rape had been black men convicted of raping white women. From 1908 to 1951, only Texas, North Carolina, and Georgia executed more black men for rape than Virginia. The case of the Martinville Seven was taken up by outside groups, including the National Association for the Advance of Colored People and the Civil Rights Congress. The NAACP's interest was in establishing legal precedent for the benefit of due process and equal protection in general, and the Negro's right in particular. Their concern was ensuring a fair trial. In their appeals, Martin and the NAACP discussed the unfairness of the venue, the pressure on later juries to arrive at the same sentence as the earlier ones, and the historical racial disparities in application of death penalty sentences in the state. They noted the assaults of Floyd had no evidence of homicidal intent. The Court of Appeals upheld the rulings on March 13, 1950, with Chief Justice Edward Hudgens, writing, "One can hardly conceive of a more atrocious, a more beastly crime." Together, representatives, both black and white, of the CRC and NAACP, as well as other citizens, met with battle in June 1950 to appeal for a pardon of clemency for the defendants in the case. They argued for lesser sentences, but battle resisted their pleas. In 1977, in its ruling in Cocker versus Georgia, the U.S. Supreme Court ruled that it is repugnant to an enlightened society for the state to kill a person for a crime that does not result in death, declining to extend the death penalty to a person guilty of raping an adult woman. All of the appeals by the NAACP failed. The 7 black men were executed at the Virginia State Penitentiary in early February 1951. The first 4 were executed at 15-minute intervals on February 2nd. The remaining 3 were executed on February 5th, 1951. It is the largest execution for rape charges in the United States history. The day before the youngest of the 7 was executed, he said, "God knows I didn't touch that woman, and I'll see y'all on the other side."